appreciate it.
Deputy, sir, we've got the resolution of Ms. Clampett, so we can take her in any order.
Okay, good morning. We're here on our miscellaneous criminal day for the date everybody knows or should know, February 14th. One quick remark, there are a number of individuals that are on the docket this morning who do not have an attorney. Most of these are based on issues relating to a violation of probation. Some of you may be having discussions with the state regarding the violation, if it is, assuming it's a violation. But I just want everybody who does not have an attorney to know that you will have the option here today to accept an attorney and basically deny the violation of probation so that you can talk with your attorney. Not today, but talk with them before you have to take any substantive action. So just keep that in mind, because you'll be coming forward when your name is called. You can come forward, and I'll be asking you, do you want to have an attorney? You've got to file for the financial affidavit and be approved and whatnot. But for today, you will be able to accept a provisional public defender, and the court will enter a denial on your behalf. So you don't give up any of your rights without kind of knowing what the heck's going on. Okay, so I just want to kind of let everybody know that. Okay, so let's go ahead and begin with Mr. Moore. Find your...
Ratton. I believe it's 22 CF.
I got it.
Yes, sir.
22 CF 255.
Yes, sir. Your Honor, Mr. Branton is in prison right now. The state and I were trying to reach an agreement regarding a plea. We've not been able to do so at this time. Mr. Branton had asked me yesterday if he could be transported to Okaloosa County to litigate. I talked to the state about that. They have no objection. That would, of course, though, make him lose gain time. So I do not know what course he is going to take from here. So it needs to be continued.
How long? I mean, how long?
Yeah, we're leaving on the 21st, Your Honor.
On March 21st?
Yes, that'd be fine.
Okay, so we'll continue it to March 21st at 9 a.m. and try and figure out where we're going from there.
All right.
Okay.
Thank you, Your Honor. That's all I have.
Thank you. You have a good day.
Thank you.
Mr. Noakes? You want to just start from the top?
Your Honor, I've got Jeremy Thomas Sullivan, 20 CF 698, 20 CF 952, and 20 CF 1545. I had initially filed a motion to have him transported here because he had a failure to appear that triggered, and then he ultimately got sentenced to DOC out of Santa Rosa, which put a hold on him. So I filed the motion and said it today, but undoubtedly you signed the order to transport him anyway. He has now been served with everything, so I think probably the best is to get the next court date and give me time to talk with whoever the state's being represented by at this point, so we can try to get it resolved next time.
Okay. So how long do you want to come back on another miscellaneous? Who's handling this for the state?
Yes, Your Honor.
I apologize. I am.
Okay. So how long do we need? We've got a miscellaneous date on,
I did a little bit, I'd say, like 2 weeks a month, something like that. That's right, okay.
I guess they're technically new cases, so, I mean, I don't know when your next pretrial is.
Yeah, that's fine.
so you want to put these on a pretrial?
Sure.
Okay. So the next pretrial is February 15th, excuse me, April 12th for inmates. Correct?
Yeah. We should be able to have it resolved, Jeff, by then.
You do not have
Is it?
February. What do you have on yours? This doesn't show this. April 12th.
April 12th at 9?
Correct.
Very good, thank you. See you after I talk.
And the motion to transport on this, just so the state knows this, I thought it was without objection. That's why the court entered it. I didn't realize that it was a contested issue. So I wouldn't normally do that. I'm just letting the state know that.
I certainly, I'm not sure who objected to it, I certainly wouldn't have, however,
Okay,
so.
so it wasn't objected, okay. So is that your only, you've got a couple other
Yes,
cases?
Your Honor, yes, Mr. Atkins.
Hold on a second. Mr. Nopes? Yeah,
I
you
think
did.
you recently got appointed.
Let me just we'll be right there. I've got a Billy Dean Adkins.
I did get appointed.
It's a violation of probation.
Yes.
Is he here? I don't, he's in the jail.
Yes, he's in jail. And we need another advocate.
And just so the court and Mr. Notes are aware, he has the new case, which is the subject of this violation.
Somebody is hitting their mic.
It's me, Your Honor. I apologize. I'm plugging something in. I'm trying to avoid it.
That's all right.
The subject of the violation is on this afternoon's plea day docket.
The one in?
The new case, which is the violation, is on
The
this
basis
afternoon's
for the violation is on this afternoon's
plea day docket.
plea day docket.
We're going to enter not guilty on that, I mean, denial, because that way I don't have to come back there.
No, he's your attorney.
That was what I figured you wanted.
Yeah, I got appointed, like, so we're going to deny the VOP that's set for this afternoon. We'll get a new date and I'll figure out what the state's offering.
Let me go ahead and announce the case number so you've got those. So the violation, the new law charge on this afternoon is 23 CF 114, basically possession charges. And you're entering not guilty on that case?
Yes, sir.
Okay. And we'll come back for our April 12th pretrial. And then the 3 violations of probation that are based upon that are 17 CF 3457, 18 CF 184, and 18 CF 2294. And the court, I'm hearing you say you're entering a denial on those 3, and we'll come back. We'll just run them on the pretrial with the new law charge.
Yes, please.
So we'll come back on 4/12 for those.
And Your Honor, I have an HFO notice that I need served in open court this morning.
Okay?
And I'm handing it to the bailiff. The bailiff is handing it to Mr. Notes, so if the court record will reflect that. And the defendant has been served through his attorney with the HFO notice.
Okay.
You can have that. We understand, Justice.
Okay. Anything else we need on these, any of these cases, Mr. Nopes?
Not that I'm aware of.
Okay. Very good. Thank you very much.
Thank you, Judge. Is that all?
Yes, sir. I think that's all you got.
Thank you.
Okay, Mr. Patel.
You will have to come back at 1:30.
Good morning, Judge.
Good morning.
Jay Patel and Tim Shaw on behalf of Jared Stevens, 21 CF 3196. We're before the court on a motion to reinstate bond. Has the court had the benefit of reviewing my motion?
I have reviewed your motion.
Okay. Judge, we're before the court asking to reinstate his bond on a couple bases. Mr. Stevens is from the Tampa, St. Pete area. While he was up here, he was charged with this incident. He was given a bond by Judge Paulson after an extensive hearing in which he posted that bond. He was ordered to have pretrial services and a GPS monitor. Officer LeQuay had asked that his bond be revoked based upon issues with GPS and checking in. After, this was unbeknownst to me, she had sent that straight to the court, and then his bond was revoked. He was taken into custody. In speaking with Officer LeQuay, I asked what what was the rationale behind, what was the issues with the GPS and the checking in. And basically she said it was just, he had some issues making sure that it was completely charged, and the checking in, it was just difficult because he was in Tampa and he was having difficulty getting rides up and coordinating meetings with us to come up with us and come up to see pretrial services. So in speaking to Officer LeQuay, I asked, would you be okay with supervising Mr. Stevens if he stayed in the Okaloosa, Walton area, still had his GPS? She told me over the phone that she wouldn't have an issue with that. So that's the first issue. The second issue is during depositions last December, we had Investigator Henderson, who's the lead investigator on his case. I had asked for months and months and months, I need to see the FDLE lab reports. And they kept sending me drug reports from a co-defendant. So finally, when we get to the depositions, I said, Investigator, where's the DNA? Where's the FDLE reports? And she goes, yeah, so we made a mistake and we didn't send it off until yesterday. This is almost a year into, actually no, it's over a year into the case, just over a year. She indicated to us that there was blood on 2 knives, one of which they believe was in the possession of Mr. Stevens, one of which was in the possession of another person. We believe that this evidence is, that lab report is wholly exculpatory. We need it before we can proceed forward. Because of that, now we're in a situation where if Mr. Stevens is incarcerated doesn't get a bond, then his case is being delayed for months and months and months for no reason of him, but actually of law enforcement. We think that that's just patently unfair. So I'd ask, based upon those reasons, that the bond be reinstated with the modification that he's to reside in Okaloosa or Walton counties, with all the other, or any other reasons that, or any other items that you think would be necessary.
Counsel for the state.
Your Honor, what the defense has left out is that Mr. Stevens has also picked up a new charge in Pinellas County, Florida for abuse of a dead body, principal to that. The state has also spoken to Ms. LaCroix, and what she has told the state is that they are a neutral third party, and if the court were to order that they had to supervise Mr. Stevens, they would, but they were not necessarily amenable to supervising Mr. Stevens, because they did file a violation of his pretrial release. And to quote their filing, he missed 4 consecutive check-ins in 30 days. He was previously warned and reminded. He's required to charge his GPS fully. The device had only had a full charge of a total of 5 times in the last 30 days. They also tried to contact him and were unsuccessful because he no longer had a valid number. He had multiple contacts with law enforcement and failed to report them. And he'd been evicted from multiple motels and trespassed for suspected drug dealing and prostitution. The state does have a copy of the Pinellas County report. If the court would like that as State's Exhibit 1, if I may approach.
And you've seen this?
I'm acutely aware, actually not acutely, I'm very aware of that situation. I would ask if Ms. Sandler can tell the court whether or not she's spoken to that prosecutor, because when he called me about 3 weeks ago, they weren't sure that they were even filing an information on Mr.
Your Honor, the
Stevens.
state checked yesterday, the information's been filed.
And that statute that they were talking about filing, so evidently they may have, refers to sexual abuse of the corpse, which is wholly not even close to what's in that PC.
So you're arguing their PC down there now?
I mean, I think that the court needs to understand, if they're gonna make that argument, then I think that we need to talk about it.
Well, but there's a PC that's been filed, in order to issue that. I don't know whether that's before the court. But before the court, there's been another charge that's been filed.
But again,
Anyway, can I just, help me out here? We're talking about what everyone else is saying. Is this just like wide open that we can like talk to any other officers of the court? The state's talking to their people, you're talking to people, all hearsay? Is this, certainly the court has to take this into consideration. This is a little different than having somebody here testifying, or is this, nobody's objecting, so I guess I shouldn't be objecting. I'm not objecting, but is this appropriate testimony of counsel for the state? Help me out. Mr. Patel, what do you think?
I'm not making any objection. The only person that I was, really talking about of substance based, really hearsay is Officer LeQuay, who's an extension of the court, which the court can, I don't have any problem if you call her.
Okay. We're having a hearing today. I'm not going to call her separately. That's up to you all.
But
Your Honor, generally in these bond revocation hearings, we do rely on hearsay. It makes it more expeditious, but if the court would prefer to have live testimony.
No, but I'm more dealing with this. This is not your garden variety bond revocation hearing. This is a serious, a lot of substantial issues have been raised. You contradict essentially the officer that he's using as a basis for his arguments. Anyway, anything else that you want to?
Yes, Judge. The one thing I didn't hear the state.
Yeah, thank you for that. I don't mean to interrupt you. I did want to have the state comment regarding the FDLE test. Were they delayed a year, and what is the timeline? No matter what, whether they were delayed or not. But there's two questions. One, is that correct? Was it delayed a year based on a mistake by the state? And secondly, what's the timeline for the test? I know we've got real problems with FDLE.
Your Honor, I know everything was sent off. We checked back on December 19th of 2022. We're still waiting for an update from FDLE. I would have to ask our assistant to check on the status of that, make sure it's been assigned to an analyst. This is Ms. Davis's case, and I'm covering for her today in full discretion. She's out on a medical issue with her child. I couldn't tell the court what the delay was in OCSO turning everything over. I know that this incident is on video. I'm not sure if that was an executive decision to save the resources of FDLE because this incident is on video. I'm not sure about that. I can check on that for the court, absolutely. What the state would point out, however, is that the court has the power to revoke bond upon probable cause of a new offense. There is probable cause of a new offense that also happens to involve a dead body.
In the FDLE, you said that you believe, I just want to make sure I understood you. Was there an analyst? Has there been an analyst assigned?
There should be an analyst assigned, Your Honor, but I can check on that quickly.
And when, do you know, or either party, when was it sent into FDLE?
The judge, they took all the stuff in custody back when they arrested him.
I understand that. I got that. Yeah. I'm asking when it was sent in.
Oh, no, I mean,
no,
I mean, I can tell you as an officer of the court, Kelly Henderson told me and Mr. Shaw, they sent it just the day before of the depot date.
Which was kind of
that late December 2022.
I don't think so.
This would be December 19, 2022.
Okay, so I'll assume that with the state not contradicting, I'll assume that's correct.
Because more importantly, that day we were furnished with her full report that we never previously had.
Sure. So the court will acknowledge that I am a little troubled by the delay in the FDLE report, and that's why it's important for us to come back every pretrial so that we can track these discovery issues, and hopefully I will do a better job with the court of uncovering if there are outstanding discovery issues that are out there. So I'm troubled by it, and all things being equal, I would probably that might be an excuse for me to reestablish the bond. But based upon the overall issues and the number of other issues, not the least of which is a new law charge, the court is going to deny the issue to reinstate the bond based upon the issues raised by the state at today's hearing. And the court will accept this into evidence without objection.
Yeah, no objection.
It states Exhibit 1.
We'll be up to the jail proceed.
So we're set for, you want to deal with the trial tomorrow?
Actually, yes, if we can.
Hold on one second. JJ.
Just save me from having to come.
I appreciate that.
Sure.
Judge, we're back on the record with Jared Stevens, 22 CF 3196. The court had inquired if we could handle tomorrow's pretrial today, which Mr. Shaw and I do not have an issue with. Judge, we'd ask.
Is the state prepared? I know you're covering. Let's say Ms. Davis said, yeah. Go ahead. Let's see if we can get it done today. If not, we'll
Sure.
look at tomorrow.
Judge, we have depositions set in this case in the coming weeks, a couple of which are in Pensacola with the medical examiner. Based upon that, we'd ask for a one-cycle continuance.
Okay. So, obviously you've raised the issue of the FDLE reporter. Are there any other discovery issues that you're aware of that I just want to be able to kind of let you know that if there are issues the court wants to move, particularly these are complicated cases. The court acknowledges that, wants to make sure everybody gets their day in court and everybody gets the processes that are available to them, both in the state's case as well as the defense. So let me know if there's some issues that I can help with.
Outside of the FDLE, we had 6 witnesses not show up for the first round of depositions, so we're going to reschedule those after we go to Pensacola. And
I know that's an ongoing problem.
And if we need the court's help, we'll enlist it.
Okay, very good. So we'll come back on our next pretrial. The court will grant, the state not objecting to the
No
continuance.
objection, Your Honor, and we're attempting to get an uptake for the defense on the FDLE right now.
Okay, great. And so
Is there a way to get a court order?
Not that I'm aware of. I don't even know if I have the authority to order the FDLE to do something, but at this point, what I will say is that seeing that this is the first time it's been brought up, my attention, maybe it's the first time you've become aware of it, but the state, we need to make a note, Madam Clerk, that the state, in the minutes, the state is going to inquire about the status of the FDLE and will be prepared to explain to the court what the status of the FDLE report is at the next hearing, which is
Judge,
April 12th.
Speaking to Mr. Shaw, I think that if we don't get the FDLE in a month, I'll file a motion to compel, and that will put the court in a position to have power to do something.
Sure. Okay.
And we should have an answer to the defense within the hour on the status of the FDLE. Investigator Henderson's already texted me that she's contacting FDLE right now.
Okay. We want to do that. I mean, you have a right to know where we're at with these things, particularly when there's delays, and we're going to, court will do whatever it needs to do to try and get you the report that's due you.
Thank you.
Okay, thank you.
We're here.
You've got a couple others, don't you?
Judge Tim Shaw and Jay Patel for Michael James Wilson. That's 2020 CF 1113. Judge, we're here on a motion to continue the sentencing, which is set for February 21st at 3 p.m. The motion to continue, Mr. Patel laid out pretty specifically the basis upon which we're moving to continue. As the court is aware, this is a 25-count information charging the defendant with possessing photos, motion pictures, etc., which include sexual conduct by a child. We had been set for sentencing on September 15, 2022 before Judge Brown. We appeared at sentencing on that day with probably 20 or 30 witnesses. At the hearing, the state indicated they were going to move to disqualify Judge Brown based upon his relationship with the step-grandfather of our client. Quite frankly, I think they knew that all along, but that's what they did that day. On the date of the sentencing, that's what they did. They actually filed the written motion to disqualify on September 23rd. 27th, the order of recusal was entered. We then, based upon the sentencing letter provided to the court by the state, filed a motion to take the deposition of the state's computer expert, Christopher Campbell. The state objected to that. We had a hearing on it. The judge allowed us to take the deposition, which was conducted on November 9th. During that deposition, new information was discovered related to certain charged counts. And 2 reports were subsequently provided to the defendant based on the new information learned. In addition, Mr. Campbell made assertions in deposition on page 35, lines 5 through 13, that the defendant knowingly viewed and knowingly possessed illicit material, charged or otherwise, in 2016 and 17. Mr. Campbell was pressed further, stated he was not sure and needed to look. Defendant, having conferred with his attorneys and an expert retained, made a specific discovery request on February 6th. The state's response to the specific discovery request is crucial to the defense of the defendant, his ability to present argument at sentencing, and to rebut the claims the state has made in their sentencing letter to the court. Obviously, whatever we find out may obviously influence the court's decision with regard to sentencing. Additionally,
so what needs to happen? What are you asking? What needs to happen before the sentencing that you're claiming?
Yeah, and we've provided the state. Mr. Patel also provided a written specific discovery request to the state, also filed on February 6, 2023, which lays out specifically what we're requesting from the state. I can read that to you if you'd like.
You can summarize. I mean, I don't know if
it's a small. It's not long. Production of all evidence relating to any files containing illicit material, charged or otherwise. Defendant played on a media player. 2, evidence of activity on defendant's computer for any files containing illicit material, charged or otherwise. 3, evidence in this case for file attributes from Dropbox for the charged files regarding when and where they were uploaded from. And 4, evidence of IP addresses collected in this case in connection with the use of Dropbox and downloading illicit material, charged or otherwise. It's an interesting, and if we get too much deeper into the computer stuff, I'm going to have Mr. Patel talk to you about it, but Dropbox, it's kind of unique how these items may get into someone's possession without them even knowing it. So,
Your Honor, just to clarify, we were set for sentencing with Judge Brown, and at that hearing, Judge Brown called all parties up to the bench and disclosed the nature of the relationship and the extent of the relationship with the family. Based on that, we had no other recourse but to ask that he disqualify himself. So that was at the hearing itself.
So you're saying you didn't have prior knowledge of that and we're not withholding the recusal request until the eve of the hearing?
That's correct, Your Honor. And we had reason to know certainly that parties might be acquainted with each other. It's a small town. Attorneys know each other. Mr. Pinkerton was well known. But to the fact that there was that much and the extent to which Judge Brown disclosed the relationship and the interaction with the family, we felt uncomfortable and therefore we filed it. So just to clarify that. But Your Honor, we're opposed to this continuance for many reasons, but if I may go back, Mr. Wilson, their client, pled back on the 18th of July 2022. Prior to that date, all discovery had been provided. There has been nothing new since that time. Now, so everything was provided to the defense, including everything in the specific discovery prior to the plea being entered. Mr. Patel, Mr. Shaw, their expert, Mr. Green, were all allowed to go to the lab and view whatever materials they wished to view that we were not able to provide. Additionally, at their request, we provided actual disc of all the Dropbox listings, and any reports that they requested were all provided prior to the plea. That plea was then entered based upon that sentencing hearing was set, and it has been rescheduled many, many times at the request of the defense. We feel like this is just another way for the defense to avoid their client ultimately going to prison. He does square up presumptively to, I believe, 97.2 months up to 125 years for the charges. Your Honor, additionally, the defense mentioned that they were able to take the deposition of Mr. Casey Campbell, who is our expert who did the forensic analysis, on the 9th of November. They would like the court to believe that new reports were provided after that. There were 2 reports provided after that. They were hard copies of something they had already been able to view at the sheriff's office. So they're not new reports, they were not new information. Then apparently that caused the defense a concern, yet they wait until the 6th of February to file the request for specific discovery and the motion to continue. We believe that's a bit disingenuous because they're waiting 2-3 months and now asking for another delay. They've known this since November that it caused them concern. But I would reiterate to the court that all reports that Mr. Campbell was going to testify from have been provided. They were provided or available for viewing prior to that plea in July of 2022. So we are objecting to the continuance. As far as the request for specific discovery, there is nothing further we can give them. We have given them everything as is required. And made our expert available subsequent to a plea being entered, subsequent to the time they felt that they knew everything and knew enough to enter the plea. Mr. Campbell was being called at the sentencing hearing to refute the assertions of the defendant as far as whether or not he had knowledge or knowingly possessed. Everything he was going to testify to was provided previously to the defense in the reports.
Counsel for the defense.
Look, and I don't want to get petty or anything, Judge, but if somebody's being disingenuous, it's not the defense on this issue. I made it very clear from day one who the defendant was and who his step-grandfather was with the prosecution. So to wait until sentencing, the day of sentencing, to make that motion is to me, what's disingenuous. The allegations, I think, that
did Judge Brown not bring you up to the bench to explain his relation, basically say, hey, I want you guys to be aware of what I got here.
He did.
If you all do that.
He did, and it's not uncommon for judges to do that.
It isn't uncommon.
Not uncommon.
You're right, and sometimes we would always like to do it well before the hearing,
right,
if we have it, but sometimes with the 1,000, and I'm not exaggerating, the 1,000 criminal cases that we handle, sometimes we come to a hearing or in preparation for that hearing, are made aware of something that we maybe would have preferred to have brought it to everyone's attention 6 months ago, but we bring it to you, the eve of the hearing or at the hearing, because we just now kind of got on my screen, got on his screen. So
but my and Judge, I understand that, but my recollection of what was disclosed by Judge Brown was so minor and minuscule that it would not have had any effect on the state. But that's up to them. So.
okay. Well, I'm going to default to the not being disingenuous on either side, and that there was a legitimate issue that was raised and acted upon. That's what I'm going for. I've been shown enough to go past it. What about the more substantive issue of the?
If I can respond to that.
You may.
Judge, I've got practically speaking, and I'm not sure if the court's ever had the benefit of having represented somebody with these allegations, but when the state says, oh, you can go to the sheriff's office and you can see this stuff, and that's fine if it's pictures and videos, but to study file attributes, you can't just do it on the fly. You have to have it in your face, and you have to study it and look at it. And so they never sent us these until literally it says report generated November 10th, 2022. Had they sent this to us, they would have said, refer back to the discovery exhibit we sent ages before your client entered the plea. The issue that I have is that we understood this case to be on one specific track, where we didn't really have a whole lot of difference of opinion as to the mechanics of the case, given our client's confession, which was consistent with some of the evidence. However, as soon as we get to day of sentencing, there are allegations lodged in their sentencing letter that that is a part of the record now that are wholly different than anything that we ever knew or believed. That is why we did the deposition. Then when we do the deposition, we get Mr. Campbell isn't really sure. I think he even so much stated off the record, I may be getting this case confused with someone else, which is okay. Let's talk about it. Let's find out. So we get these reports. It takes a while between getting the deposition, getting the reports, making time with our expert for him to review, us have a meeting, and then getting with our client, and then meeting, and then figuring out what we want to do. There wasn't any undue delay. The problem with this is that in these reports, out of the 25 counts, only 2 of them are in this, and the source file is and this is the most concerning part. It says Dropbox.SarahSueJones blah blah blah, which indicates that the source of these files were from a Sarah Sue Jones's Dropbox. We need to further analyze the basis of this. If you can imagine.
Were these charges not admitted to?
They were admitted. Mr. Wilson.
I'm just trying to kind of understand your argument. It seems to me that you're arguing that these really weren't his.
So that's where this case is super interesting. This case is about a Dropbox. Yes. This case is about a Dropbox in which Mr. Wilson claims ownership of the Dropbox. He does not specifically know, nor can the state show us that he specifically knew of all of the evidence inside the Dropbox. There were some 11,000 or 10,100 and something files, of which I believe it stated that there were 40 images and videos were suspected or actual CP. So that's where what's in the Dropbox and the depth of the Dropbox becomes an interesting argument. It's not a situation where it's like he got caught red-handed.
So let me ask you this. What are you all, what amount, I was gonna ask you, what do you need to do? But what I'm really trying to get at is, how long are you asking for? What are you asking for? You're asking for a delay. How long? What do you all need to do? You need to take somebody's deposition? You need to look at the files again, or are they even available? I don't know.
Well, really what we need, Judge, is probably just a 1 or 2 month continuance and the state to overtly state that they're going to comply with the specific discovery request or say we're not going to. Because I don't think it's fair that they get to argue both. They can either say that, yeah, we're going to give you exactly what you requested, or we're going to say, no, we don't have it and we're not going to give it to you. And that's important for us.
I heard them say that they've given you everything that they've got.
They like...
Is that true or not?
That is true, Your Honor.
Then how come we got a report that we've never seen on November the 10th, 2022?
Because you specifically asked Mr. Campbell for a hard copy of that printout, and he got it for you. It's part of a bigger report that you all have always had access to. It's magnet forensics, it's the analysis. And Your Honor, I will also say that a lot of this stuff that they're saying is a surprise to them, because of who the family is, they have both tried to speak to my boss and have a meeting with Mr. Ankers about trying to get the state to reduce the charges. My notes from that meeting indicate the same things that we were going to raise at the sentencing hearing. So none of this is new. It's all the same evidence that's been around and around and around. So as far as answering the specific discovery request, we've given everything we have. We've given them access to everything we have. Can I tell you they've looked at every single piece of information available? No. Because I don't know exactly what they looked at while they were over at the sheriff's office, but I can tell the court everything's been made available to them and to their expert. So as far as answering the specific discovery request, all I can say is you've got everything.
I'll give you the final word.
I'm sorry, Judge.
I said I'll give you the final word.
Judge, if the... Well, I'll let you.
Judge, there's nothing, in our opinion, that no one is harmed by continuing this thing for a month or two to let us make sure of this so that the court gets it right and has all the information before the court, before making a ruling. Quite frankly, we were ready to go back in September, or thought we were ready to go back in September when we started getting this new information. We did not understand.
How long of a sentencing hearing are we talking about? You just said something about 25 or 30 witnesses. You trying to spook?
I'd say several hours, Judge.
Three. So an afternoon.
Yes.
So what do we have on February 21st, the sentencing? What hearings do we have? It's impossible to do that. I don't know how these were set all on one time without somebody questioning the amount of time. It's impossible to do 3-hour hearing when there's 9 other hearings scheduled for that afternoon. We've got to figure out how to schedule them. It sounds to me like we need to have a, on March 21st, is there in the afternoon? And if we schedule it for that, you can block that where not somebody else who at the desk somewhere else is going to set something? Okay, thank you. I'll continue it until March 21st in the afternoon, all afternoon.
Thank you, Judge.
It's a trial, Judge, we'll make it work.
Okay.
Thank you, Judge. I believe that's all we have.
Thank you. Mr. Madden, Good morning, Your Honor. Mr. Madden.
Good morning, Judge. John Madden here on behalf of Jamel Efat. This is 22 CF 787. Judge, this morning, I've talked to the state. We're going to be getting some more information from them and trying to negotiate this case, hopefully in the future. As for this morning, we're going to be entering a denial as to the violation and ask for a new court date.
Very good. So the court will enter a denial. And so do we need, you want to come back on a, without subpoenas?
Yes, sir.
Okay, so we'll come back March 14th.
That should work, Your Honor.
Is that good?
Yes, sir.
We'll come back on March 14th in the morning without subpoenas. 9 a.m.
Thank you very much, Judge. That is all I have, if I may be excused.
Thank you very much. Fine. Mr. Stokes.
Good morning, Your Honor.
Good morning, sir.
Ted Stokes from Matthew Sweeney. Judge, I'm pretty new on this case. I filed a notice of appearance.
There's two cases.
Two
Why don't
cases.
we go ahead and announce those as 20 CF 1460 and 20 CF 1637.
It appears that Mr. Sweeney had entered a plea in the case. Brooke Davis was representing him and withdrew. And in the meantime, he was sent to state prison and now brought back. At this point in time,
What are we here on this morning? I've just got it listed as miscellaneous. What?
Your Honor, the defendant failed to appear, or I'm sorry, I think this is a new case, Your Honor.
failed to appear because he was in state prison.
So this case is just back on the docket, and we just need to figure out kind of where this is going.
Okay. So there's two cases here. Are these both open cases? What is the status of it? I haven't reviewed the whole file, so somebody kind of help me out here. Get me up to speed.
Your Honor, so it looks like they're both open cases. They have not been pled to yet.
Okay. So they just need to go on a pretrial docket?
Well, I mean, we can leave it on a miscellaneous, if the
Are
court
these new
prefers.
charges or these violations?
They were set for sentencing from reviewing the court file. They were set for sentencing back in 2020 or 2021, and then the defendant failed to appear, I believe, because he got new charges.
So he pled, and there was a sentencing set for
And then
both of these cases? He got new charges, got sent off, and he's just now coming back?
Yes, Your Honor.
Mr. Sweeney, are
I
you
believe
aware of
that's-
that?
Yes,
Mr.
sir.
Stokes, excuse me?
Yes, sir.
So
We're
what do we
hopeful.
need to do? Do we need to set a sentencing?
Yes, we're hopeful to be able to do like a concurrent plea or something, but I'm just new on the case and I need to.
Your Honor, Mr. Stokes did reach out to my office. If we can, if he can be available on the 21st, I believe that I can get him an answer to the request that he made by that time. I don't want to try to delay this and too much. If he can be here on the 21st, I believe that there's something we can communicate more by the 21st, if that's a date that is available for him.
So February 21st? We have one March 21st too. Did you mean February 21st?
Yes, I meant February
Okay,
21st.
so
I'm sorry.
we'll continue this until February 21st in the morning without subpoenas. And hopefully we'll get a better idea of kind of where we're at with regards to the sentencing, or if there's some other type of accommodation that can be agreed to by the state.
Thank you
Okay.
very much.
that
Good
good?
to see you, Judge.
Okay, thank you very much.
Get it over with.
You want to just go through the inmates? Just follow?
Yeah, I can start bringing it in. I don't know if they have.
You want to do the no attorney?
Sure. I get 25.
You want to start with Brown, Derek Brown?
Yeah, Brown and Gary.
Okay.
Huh? Yeah.
So what we're going to do is we're going to do the no attorneys first. Because first one we're doing is Derek Brown. The state will announce when the defendant comes out. And then we're going to do Gary after that.
I appreciate it, Your Honor. I'm appointed to Mr. Gary's case.
You were appointed, or you want?
His new law, which is set in the afternoon, Your Honor. I can handle the VOP too.
Okay, so that, you've already been appointed?
Not on the VOP, Your Honor.
Okay, come over here.
Your Honor, this is Mr. Brown. He has 20 CF 643. I believe he also has another case on the docket, which Mr. Medina is appointed to. That's 19 CF 2157. So the
Yes.
court wants to make sure Mr. Medina is appointed to both cases. I think that'd be prudent.
So Mr. Gates thinks it's his case.
Mr. Gary, Your Honor. That was who you called.
That was Mr. Garrett.
Yes, Your Honor.
Okay. We'll get this straight. Okay, Mr. Brown.
Okay, may I, Your Honor, I didn't know who this was. May I just have a moment?
Sure.
Thank you.
He has not been appointed counsel on the VOP case, so let me ask him whether he wants to have an attorney. Is that all right? Since you're handling on the other case. You want to have an attorney appointed? Okay. Court will appoint you the public defender provisionally.
Your Honor, and my understanding is that Mr. Brown, I just talked to the state attorney's office about this a little earlier, and they said he has a 12.15 months DOC guidelines offer. I know that he was wanting to resolve this. It probably can't be resolved today. Can it be resolved today? So, Your Honor, he can go ahead, and has an information been filed?
Your VOP.
Oh, it's just a VOP, okay, so he could just deny the VOP, Your Honor. I apologize for my confusion, and we will, I think what happened is that our Crestview office has the file, but I'm giving it.
Okay. So February, what are we looking like on the February 21st and 23rd, Madam Clerk? We have plenty of availability. What do we have?
If we could bring it back in the morning of the 21st, we may be able to resolve this case, Your
Sure,
Honor.
that's what we're going to do. We'll bring it back in the morning. I just want to see what the... What about the 23rd?
6 cases. 130.
So we just want to go. So February 21st.
Thank you, Your Honor. 9 a.m.?
9 a.m.
Thank you, Your Honor.
Thank you.
So hopefully we can resolve it then, okay?
So Mr. Gary's coming out next. The state would announce.
Your Honor, Mr. Gary's here on the violation of parole on case number...
Violation of parole?
Probation, I'm sorry, 22, looks like 142, and also 22,
CF 737, correct. So, Mr. Gary, these are based on, I believe, on new law charges that you're on for this afternoon. And I believe that you have, your attorney stated he's already been appointed. There we go. Mr. Gates, so the first thing on these new violations that are based on the new law charge, you have a right to have an attorney appointed. So he's been appointed on your new law charge, but not on this violation of community control. So you wish to have counsel appointed on these cases as well? Yes. Okay.
Yes, sir.
Yes. The court will appoint the public defender, and I assume we just want to deny today?
Yeah, we have a plea agreement to be filed to cover
Oh, really?
DOPs and the new law, Your Honor.
You're way ahead of me.
I try to be, Your Honor.
Okay.
May I approach?
You may. Thank you. Thank you very much.
And the score sheet is accurate, no objection to that, Your Honor.
Thank you.
Mr. Gary, before the court as announced in 22 CF 142, violations of probations, 22 CF 737, violation of probation, and then 22 CF 3152. He'll be admitting the violations in both 22 CF 142 and 22 CF 737, pleading no contest as charged in 22 CF 3152. Be adjudicated guilty all counts in cases. In 22 CF 142, revoke and terminate probation, sentence to 36 months, Department of Corrections with credit for all time served. $100 cost of prosecution, $150 public defender fee. And 22 CF 737, revoke and terminate probation, 36 months, Department of Corrections, concurrent with credit for all time served. $100 cost of prosecution, $100 public defender fee. And then the 22 CF 3152, count 2, he'll be sentenced to 36 months DOC as a minimum mandatory sentence. That'll be concurrent with credit for all time served. In the other counts, withdrawal felony counts, will be 36 months DOC concurrent with credit for all time served. 615 in court costs, 100 public defender fee. Mr. Gary Zess to send all outstanding court costs to collections.
That is the state's agreement, Your Honor.
Very good. Sir, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, you heard your attorney state the terms of your plea agreement, and I see that those same terms are contained in the written plea agreement that it looks like you've signed. Have you gone over this plea and sentencing agreement with the terms and all the other things in detail with your attorney? Make sure you understand all the legal ramifications, because there's a lot of legal stuff in here. You understand that you're, by entering this plea agreement, the big thing is you're waiving the right to go to a trial on all these.
Yes.
Okay, and you believe it's in your best interest to do that?
Yes.
This will be a final adjudication of your case. Have you had all of your legal questions answered?
Yes.
You believe anybody has threatened or coerced you to get you to enter into this plea agreement? Based upon that, the court will accept your plea agreement and will sentence you to the 36 months in the Department of Corrections on each of the 3 charges. Each of the 3 counts, there's actually a number of counts on the 3 cases, but all of these will be served concurrent. There is one thing, one of the cases in 22 CF 3152 does have a minimum mandatory. You've gone over that with your attorney about that? So it's 36 months, but there's a minimum mandatory on that.
Yes.
Okay, you've gone over that with?
Yes, sir.
Okay. So that's important. That's kind of a little nuance I just want to make sure you're aware of on this, because it impacts your gain time, I believe, when you're over there. You also have a number of fees and costs that are all contained in here. That'll be a part of that. And these will all go to collections?
Yes, sir.
Okay, anything else?
No, Your Honor.
Any questions? Yes. Okay, good luck. Is Shanika Estrella here today? Would you come forward?
He's not today, he didn't come back.
Would the state announce on this?
Yes, Your Honor. Miss Estrella has a violation in 17 CF 2135. Your Honor, this is failure to pay cost of supervision, failure to pay court costs, and failure to pay into the Department of Corrections Trust Fund. The offer from the state is to revoke and terminate her supervision and send the remaining financials to a civil lien after 120 days or however long she might need to pay that before it goes to collections.
I got an email from her officer that she paid everything in full, so we're just asking for the VOP to be dismissed.
Your Honor, VOP dismissed.
The court will dismiss the VOP. Okay, we appreciate you taking care of that.
Your Honor, is that supervision terminated for probation parole?
Supervision is terminated. Okay. Is Tiana, I don't know, first, Miss Carol here? Carol? State, Miss Carol, is that was she properly served?
Your Honor, it does appear there was an order to appear for violation of community control that she acknowledged service of on 1/18/23. It did require her to be here today. It looks like at 9 o'clock, so I do believe it's appropriately served. I did ask for a capias.
Court will grant a no bond capias. Okay. Is Robert Rawls here? You come forward, sir. Would the state announce on this case?
Your Honor, this is Mr. Robert Rawls. Sorry, I'm just collecting the file. He's 19 CF 2979. Mr. Rawls is alleged to have violated probation based on the failure to pay costs of supervision, court costs, and complete community service hours.
So just this all costs?
It's costs and community service hours, Your Honor. If the court is interested in what the state is interested in, I would be willing to dismiss the alleged violation of probation if Mr. Rawls were to complete his requirements.
They're all complete, Your Honor.
Probation have any so you believe you've completed the
yes, Your Honor. It
service
just
hours?
wasn't in the time of a manner, a month early of release of probation.
I see all his money has been paid, but not the community service hours. I don't have that.
I paid them just a week or two ago at this very court office.
So you paid to pay for the community
Yes,
service
I
hours?
opted to buy out the community service at 10 an hour.
Okay. So why don't we do this? I don't know what we're doing here, but I'm not going to take any action. So what I'm going to do is I'm going to continue this case so that, and just ask that you be in communication. If he thinks he's paid everything, if somebody can, I don't know who he needs to check with to make sure that it's either been paid or if there's a little something additional that you know he thinks he's paid it. Does he need to talk to you or to probation? Who does he need to talk with?
I don't know if probation can check if someone's bought their community service hours.
I mean, I'm sure if you pay for something, they gave you a receipt or something, right? So
I see a payment on January 17th for $240 for those hours.
Yes, that's $248 for 24 hours of community service, Your Honor.
Is that to map that up to you, Ms. Fenton?
Yes.
Okay, all right. The state moves to dismiss the violation.
okay. So the court will dismiss the violation, and is probation then terminated as the last requirements of probation?
Yes, Your Honor.
Thank you for taking care of all that. Sorry to bother you on that. Should have been pulled off the docket.
Thank you, Your
Okay,
Honor.
thank you. Okay. Coward? Well, that's Mr. Harper. Let's see, let's try and get any of, I think those are all the no attorneys. Okay, so we'll just start at the top for Tremont Coward from Mr. Harper.
If you don't mind, give me the email.
Sure. You want to do regional conflict first? All
Yeah,
the,
Mr.
just this one?
Just the inmate. He only has one inmate.
Oh, just one in there. Okay. Then we'll do the female inmates after that. you announce, Mr. Harper?
Yes, Judge. Rudy Harper on behalf of Tremont Cowell. He's before the court on 20 CF 2999 and 2490. Judge, we were recently appointed on these cases. He also has a new law violation, 23 CF 52, which is
that on for today?
It's not on today, Judge. That's actually set for 410. It was my intention in that we were just appointed, having received all the discovery, I'd asked to continue these violations of probation to track with his new case, which is set for.
You want to go ahead and enter a denial and then track with the other ones?
Yes, Your Honor.
The court will enter a denial, and we'll come back on 412. His other case was on 412, not 410, right? Can you switch it to 412? Okay, thank you.
Thank you, Judge.
Sir. Would you provide your name, sir?
My name is Gus Curley, Your Honor.
Tell me spell the last name.
Curley, C-U-R-L-E-Y, 3 students.
Mr. Curley, I don't have you on my, do you have a case number by any chance?
No, sir.
It's one of Mr. Morrow's cases?
Yes, Your Honor. Ryan
Okay,
Morrow,
sorry.
Curley.
Hold on. Oh, there you go, Curley. Gus Curley. I'm sorry.
Your Honor.
We'll go ahead and take his case since you're up here.
Yes, Your Honor, I appreciate it. If we could recall Mr. Curley, I'll have a moment with him. I haven't talked to him this morning.
Okay, very good.
Thank you, Your Honor.
Okay. So the first female, I believe, is Jamie Clampett.
Yes, Your Honor. Steve Medina with Jamie C. Clampett, approaching in 21 CF 3234. And, Your Honor...
Hold on, let me find the case, sorry.
Yes, Your Honor.
I saw that other, educating and email game on, I think it's actually, yeah, but it's actually careful. I requested. Works for me. Did I give you the police number? No.
Very good. Go ahead, Mr. Medina.
I'm just asking her one clarifying question, Your Honor. May I? We have an agreement.
Okay.
Thank you. Your Honor, I'm approaching with a signed plea and sentence agreement. If I may, I've got a copy I'll read from to announce the...
Thank you very much.
And I have a copy for, she's actually going to be doing JCS, so I won't burden state probation with the copy, Your Honor. She plans to be living in Niceville, so that will allow her to do JCS. I think at one time you lived in Walton County, is that correct? Okay. Your Honor, under this agreement in 21 CF 3234, the state is agreeing to dismiss count 3, which was a third-degree felony possession of controlled substance charge, and allow her to have an adjudication of guilt to a lesser included offense, misdemeanor possession of drug paraphernalia on count 1, and to count 2, which was already a paraphernalia misdemeanor on count 2. It would be a concurrent 11 months, 29 days probation with misdemeanor court costs. I think those would be $270 or $275. Madam Clerk, which one is it? $270 or $270? Thank you. And $150 public defender fees. She would have to get a substance abuse evaluation within 30 days with any recommended treatment to commence within 60 days. Random urinalysis, 24 hours community service. The state agrees not to file on any FTA in this case. And, Your Honor, I think I gave the court a fully executed copy, so I just wanted to make sure it has everybody's signature.
I'll check.
Thank you, Your Honor.
You did. They're fully executed. Very good. Is the state in agreement?
Yes, Your Honor, that is the state's agreement.
Ms. Clampett, would you raise your right hand?
Yes, sir.
Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement.
Yes, sir.
And those same terms are contained in the written plea agreement that I have that looks like you've signed here.
Yes, sir.
And have you gone over this plea agreement in detail with your attorney, make sure you understand all the legal issues that are contained within it?
Yes, sir.
You understand the big thing is you're waiving the right to go to a trial, right to confront witnesses. This will be a final adjudication of your case. Do you understand that?
Yes, sir.
This will limit your ability to be able to appeal, etc.
Yes,
You
sir.
believe this is in your best interest?
Yes, sir, I
Do you
do.
have any other legal questions you have of your attorney?
No, sir.
And nobody's threatened or coerced you to get you to enter into this plea, have they?
No, sir.
Okay. Based upon that testimony, the court will accept your plea here today. The court will accept the dismissal of count 3. Counts 1 will be the lesser included charge of possession of paraphernalia, and then count 2, which is also possession of paraphernalia, will be as charged. Both of those will have 11 months, 29 days of probation. They'll be served concurrent at the same time,
Yes, sir.
essentially. So it's a total of 11 months, 29 days. Then you've got the fees and costs. Importantly, is as soon as you get on this, you've got to sometimes take some time to get into these, in the treatment program. So please follow up with that promptly and take it seriously. Maybe this will be end up being a positive in the long run.
Yes,
So everything else will be as contained in the plea agreement.
Your Honor, I did not, I alluded to it, but will the court approve JCS for supervision?
Yes.
Okay, thank you.
Thank you.
Thank you. Good luck, man.
All right, thank you.
Next is Lacey Melvin.
Yes, Your Honor. Your Honor, Lacey Melvin is approaching in 22 CF 484. She is coming before the court tomorrow. I believe she's already scheduled, and we are working toward a possible resolution. If we could just continue this to February 15 tomorrow.
I couldn't figure out what it was.
Very good. We'll continue this to February 15th. She's already on the pre-call for tomorrow as well. Okay. Very good.
Rhonda DeWitt. Rhonda DeWitt.
Mr. Morrow? Where's Mr. Morrow?
He's been wheeling and dealing this morning, Your Honor.
Oh, no, he's on this case.
Who are you in? DeWitt.
DeWitt.
I'll come get her, Your Honor.
Yeah. Go get your attorney. Hold on a second. This is Miss Rhonda DeWitt, case number 22 CF 2222.
Yes, Your Honor. We're going to be entering a admission. This is a negotiated plea with the state for 60 days county jail. We're open terminate.
Okay, go slow, go through it. So what's the terms of the agreement?
60 days county jail, Your Honor, $100 VOP fee, $150 cost of defense. This is here on misdemeanors. There's no score sheet.
Okay. So is the probation being terminated?
Yes, Your Honor.
Okay. When you announce in detail, because you're making it on court record, because I'm going to be asking her whether she agrees with it, so you need to be detailed in to explain exactly what the full terms of the plea agreement is.
Yes, Your Honor.
Okay, go ahead.
So the agreement is to revoke and terminate the probation, 60 days county jail, $100 VOP fee, and $150 cost of defense.
Okay. You can go ahead and sign it, ma'am. I'll ask you some questions about it in a second. Is the state in agreement with this plea?
Yes, Your Honor, that is the state's agreement.
Mr. Witt? I need to ask you just a couple questions. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do, Your Honor.
Okay. So you heard the attorney, your attorney, Mr. Morrow. You heard your attorney state the terms of your plea agreement.
Yes.
And I saw you signing the plea agreement as well.
Yes.
Which contains these same terms of the plea agreement. Are you in agreement with this?
Yes.
Okay. And have you gone over this plea agreement in detail with your attorney to make sure you understand all the legal ins and outs of this thing? Because this has a lot of impact on you. By entering this plea agreement here today, you're waiving the right to go to a trial. Your right to confront witnesses, all these constitutional protections you're waiving in order to have a final resolution of your case, which will happen here. Do you understand that?
Yes.
Okay. Very good. No, you believe it's in your best interest to enter into this? Nobody threatened or coerced you to get you to enter into this?
No.
Okay. Based upon that, the court will accept your termination, will revoke and terminate probation. So we're done with the probation part of it. You will be sentenced to 60 days in the county jail. You'll get credit for all time served. And then there'll be the $100 and the $150 of cost of defense that are payable. How long are they payable? How long do they have to pay? Does she have to pay these? Or they go to collection?
Your Honor, the court wants to give her 120 days before it goes to collections.
Put that in. 120 days or to go to collections. So after you get out of jail, you'll have 120 days to pay these costs. You pay a little bit each month. And if you can't pay it within 120 days, we'll go to collections. We're not going to.
Your Honor, is that the same as reducing it to a lien?
Yes. Do you have any questions, ma'am?
Nope.
Thank you very much. You can bring that. Yes. The next case is also yours, Mr. Morrow. Jamie's right.
Jamisi Wright.
Jamisi.
Is it Jamisi?
Mr. Morrow, would you announce the case number?
Yes, Your Honor. This is Miss Wright here in 18 CF 639. Requiring the state has to offer.
The offer in this matter is 1129 of this county jail.
Your Honor, maybe we could recall Ms. Wright's case and I'll have a word with the prosecution before we proceed.
Sure, we'll bring her back. Okay. I'll tell you what, this will be a good time to take a break anyway, because it's mid-morning. We'll come back and we'll finish these up by noon for the remainder of this, and then we'll come back in the afternoon. So I'll just go through my list here and we will. Reginald Howard, Mr. Gates's case.
In custody, Your Honor.
He's in custody. Oh, right. Jessica Dunville.
Your Honor, she is here and has an agreement.
Okay.
This Jessica L. Dunville is approaching in 20 CF 1944. I'm going to approach with the agreement, Your Honor, and pull it up on my phone so I can announce the terms because it was handwritten.
Thank you.
It's for misdemeanor, so there's a source sheet.
Thank you.
Your Honor, Ms. Dunville has entered an agreement with the state under which the state will agree to dismiss count 1, which was a possession of controlled substance felony, in exchange for a withhold of adjudication on count 2. It will be 11 months, 29 days probation. She will have to do substance abuse evaluation and treatment. The evaluation within 30 days. Commence any recommended treatment within 60 days. And there's an asterisk because she had been doing PTI. The state had given her a lot of opportunity to continue the work on that. So she's hoping she's going to get some credit, hopefully significant credit. But JCS, which will be supervising the probation, will have to review that and make sure things deserve credit. There will be 24 hours community service. Again, that's the same asterisk. She may show proof to the extent that that is complete. Maintain gainful employment or complete 2 applications a week. I think she is gainfully employed, so hopefully that won't be a problem. And again, this may be supervised by Judicial Corrections Services.
Very good. State in agreement.
That is the state's agreement, Your Honor.
Ms. Dunville, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
And I see you heard your attorney state the terms of the plea agreement, and those same terms are contained in the written plea agreement that I see you've signed. Is that your understanding of what the plea agreement is?
Yes, sir.
Are you in agreement?
Yes, sir.
Have you gone over this plea and sentencing agreement in detail with your attorney to make sure you had all your legal questions answered?
Yes, sir.
You understand that by entering this plea agreement, you're waiving the right to trial, and this will be a final adjudication of your case. That's important. Do you understand that?
Yes, sir.
Okay. Nobody threatened or forced you to get you to enter into the plea? It's free and voluntary?
No, sir.
Okay. Very good. Based upon that, the court will accept the plea agreement. We'll dismiss count 1. Count 2, you'll be withhold of adjudication, and the defendant is sentenced to 11 months, 29 days in county probation, and substance abuse evaluation in 30 days, and then 60 to start, community service hours, and the other issues contained in the plea agreement. Any other questions? Yes, sir.
Your Honor, I just wanted to clarify, because I may have just written the word court costs. I think Madam Clerk will confirm that it's $270 in court costs and $150 PD fees. Thank you.
Thank you. Any questions, ma'am?
So you have to pay the court costs as part of your probation.
Can I do that today?
You can do that.
You can do it today, or you can do it at any time during the terms of the probation.
Okay.
Yeah, you'll be with that address about those kind of issues. Thank you, Your Honor.
Thank you.
That's who you go directly to. Yes, ma'am. Thank you.
So Kyle Bird, Mr. Morrow, see your client here.
I had called him when I first arrived this morning, Your Honor. I haven't seen Mr. Bird yet today. I don't have any information from the court.
State.
Your Honor, the state's requesting habeas.
Court will issue a no bond habeas. So you want to recall Mr. Curley?
Ryan Morrow from Mr. Curley, Your Honor. I'd ask to continue this March docket if the court would allow. have an opportunity to sit with Mr. Curley in office.
Okay. Why don't we come back on February 21st at 9 without subpoenas, so in the morning at 9 a.m.
Thank you.
Thank you, Your Honor. Thank you, sir.
Thank you.
Sure.
Robert Davis. Mr. Morrow, Robert Davis.
Yes, Your Honor. Ryan Morrow for Mr. Davis. Your Honor, we're asking the court to allow us to continue this to the March docket. Mr. Davis has made a lot
Would
of
you talk
progress.
into that mic for me? Hold on. Thank you.
We're asking the court to allow us to continue this to the March docket. Mr. Davis has made a lot of progress on finishing up these conditions, is my understanding. He only has one class left to complete and about $1,000 worth of financials.
State?
Your Honor, the state doesn't object to that.
So we'll continue this until March 14th at 9 a.m.
Thank you, Your Honor.
Okay.
See you.
Michael Harrison.
Ryan Morrow for Mr. Harrison, Your Honor. This is 17 CF 3556 and 17 CF 2395. He's asked for me to set this matter for a contested hearing.
Okay. State ready? Not today. But.
Yes, Your Honor.
Okay. So we will, what do we have? Let's see, February. February 23, we've already got about 5 hearings, I think, on that one, correct? February 23rd. What do we have March 14th? Okay. So we will schedule this for an afternoon hearing with subpoenas on March 14th at 2:30.
Thank you, Your Honor. And for the record, we'll enter a denial on the VOP if that hasn't already been done.
Okay. Very good. Okay, Kyla Hatch. Mr. Morrow.
Yes, Your Honor.
These are all your cases. Kyla Hatch, case number 2020 CF 2071.
Yes, Your Honor. She's going to be getting her plea straight up to the court on the VOP.
Okay.
And we'd ask to set this off for sentencing.
Would you state the terms of the plea agreement?
We don't have any terms, Your Honor, and the plea straight up to the court.
Okay, that's the terms.
May I speak? Please have permission to speak.
I would suggest you talk to your attorney before you speak, because I'm gonna put you under oath, and anything you say can and will be used against you in a court of law.
Yes,
You're welcome to talk if you want. You want to?
Sir. I would please.
Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Would you slide over and talk to that mic? What would you like to say?
This charge originally happened in 2021. I was sentenced to 3 years probation with taking rehab. I got put on probation, did everything that was required, and then I am violated. But the reason why this has not been handled since obviously 2021, this is an old case. I don't know if you remember me from first appearance. But I was in the Department of Corrections. I did 2 years. I just got out a month ago. I was praying that I could get time served or run concurrent because I did the time as this has been running for probation while I've been incarcerated. I would have handled it prior if I wasn't in Department of Custody to Corrections. I am working. I got a job within 4 days of working or being released from the Department of Corrections. I live in Walton County. I'm a productive member to society. I was asking and moving forward, when we do make the plea agreement or whatever the case, I don't know the legal terms, but that you maybe keep in mind that maybe that I could have time served or rent concurrent. Thank you.
What's the state's position on all this, in this case?
The recommendation from probation is just modification of community control. It's not incarceration. The state was just following probation's recommendation.
Which I just called Ms. Whitworth, and there was no recommendations. I did meet with her last week, and I have been reporting to her.
Okay, did you hear what she said?
Yes, sir.
Did you understand it?
Okay.
You want to talk to your attorney about it?
Yes, sir.
Okay. The reason why I say that is that if you file this, what is the, we go to you plead before the court, what's the potential?
Altogether, Your Honor, about 21 years by my count.
Okay. So they're not asking for any incarcerated time, but if you subject yourself to and basically plea it to the court, I may end up having a different opinion. I don't know what it is. I haven't heard anything. I just heard what you just said, and I asked the state what they're going to all be talking about it. And I just want to make sure you understand going into this thing that you're putting yourself at great risk for further incarceration when the state is offering not to, but it's I'm not here to negotiate a plea.
Yes, sir.
You wish to enter this plea, I'm more than willing. We'll basically ask you to repeat what you just said, because I'll probably have forgotten it with the hundreds of cases I'll handle between now and then. You can go through it and make your plea to the court at the time of sentencing if you wish to do that. Today you want to take a step back and talk to your attorney about this further to see if you want to make sure and plead to the court?
Yes, we did discuss that, and I was going to, because I am guilty of the violation, but I just wanted to have continuance to get the recommendation from Ms. Whitworth, I'm under supervision for Walton County, even though the charge was in Okaloosa. But yes, I would love to speak with him, and maybe just hope you keep in consideration that I did do 2 years, 24 Department of Correction, and I know you're busy and you have a lot of cases.
No. I'm not busy. This is my job.
Your Honor, in the interest of full disclosure, Ms. Mathis with probation just checked with the probation officer, and she said she is fine with credit for time served, but the state would ask make sure there's an adjudication of guilt, since it would be a credit for time served, if that's what she's willing to plead to.
You want to talk to your
I'll
client?
talk to
Talk to your client for a second.
Yes,
Make sure
sir.
she's okay with
Thank
that.
you so much.
I'm sorry.
Adjudicated on that.
Counsel, she was previously adjudicated guilty.
No, she went to prison on that. That's not this.
Mr. Morrow, the clerk said she's already been adjudicated guilty on this charge.
Okay.
No?
Yes, sir.
Okay, do you understand that, Mr. Morrow?
Yes, Your Honor, I do.
Okay. Does she want to accept this, that the state just offered?
Just be $100 VOP.
Yes, I
The
absolutely.
state just agreed to what you asked for. You want to come forward, let the court
Yes,
do that?
$250.
Thank you all. Thank you.
Okay.
Thank you.
So what are the court fees?
Be $100 VOP fee and $150 public defender fee.
Okay. He's writing up your plea agreement, so.
Thank you, Your Honor.
Well, don't thank me, thank probation if anybody. I'm just going along with their recommendation.
And how long to pay, Your Honor?
I get paid this Friday.
6 months. We'll give you 180 days.
Yes, sir. Thank you. Thank you.
And then we'll go to collections after that. State, would you sign, co-sign, please? Ms. Hatch, would you raise your right hand?
Yes, sir.
Do you swear or affirm the well, I already swore you in before. No, I gotta ask you a few questions. Would you hand me the plea agreement, counsel, when you get finished? So I just want to make sure you understand that you have to pay these fees, that's part of the plea agreement. But the rest of it, you're getting credit for time served based upon this admission.
Yes, sir. Thank you
Okay,
so
but
much.
it is an admission of the violation, so that's
I
part of the record. So I just want to make sure you've had opportunity. What's that? Okay. Just want to make sure you've had all your legal questions answered. And you understand, obviously, this is essentially what you're asking for, so that's fine. So the court will make sure and scratch out the plea to the court. And there will be an admission based upon your statement, and you'll have 180 days to pay the cost.
Yes.
And you will get credit for time served.
Thank you.
You want to put that on here, counsel? Credit for time served? Probation is terminated.
Thank y'all. Thank y'all.
Thank you, ma'am.
May I approach one more time, Your
You
Honor?
may. Want to get you, make sure you get good exercise. Here you go. Next is Ernest Merritt. Have you announced the case, Mr. Morrow?
Say again? Okay. Ryan Martin from Merritt, Your Honor. This is 20 CF 2907 and 20 CF 764. We're going to be entering an admission on the VOP. Negotiate offer. This is reinstate and modify the probation. 60 days county jail as a special condition with credit for time served. Probation to terminate after the jail sentence is served.
Okay. Is that the agreement with the state?
That is the agreement of the state, Your Honor.
Okay. Mr. Merritt, would you raise, has he signed?
He has, Your Honor. I'm just writing the fees.
I believe he already has the correct, it's credit for time served, so no, he already has it. He already has significant credit.
Well, then why don't we put on their credit for time served, so, because that's not what he just said. He just said 60 days, which means they have to make a determination of whether he's had credit for time served. But if you already know that he does, then let's just announce in court and let this man.
I apologize, Your Honor.
That's all right. Just don't want to mess up the jail.
I believed he had credit, but give me just a second. So I may be confusing him with another case. But yes, generally we let them make the determination. Your Honor, he doesn't, I was confusing this with another case, I'm sorry. So yeah, he does need to go back and they'll evaluate his credit. But he will keep.
You know how many days that,
It's not.
Normally, it's the jail's the one who makes that determination. Sometimes it's real clear, everybody knows that it's been done, you know, way over. But if there's any question, the jail, we actually, even the court doesn't get involved with that. They actually make the determination. So what has to happen is that today you'll actually be sentenced to the 60 days with credit. So you'll be taken over to the jail. They'll do the calculation.
do they do it here, sir, or do they do it in Crestview?
In Crestview. That's where the jail's at. You may. So so technically what we're doing, the state will listen to this to make sure we're wording it properly. We're reinstating and modifying probation and then sentencing to 60 days?
Yes, Your Honor. So that's so that Mr. Merritt can keep the withhold. So he's how it should be announced, I think, as reinstate and modify for 60 days of Okaloosa County Jail with the credit that he already has. So
Right.
he gets the credit he's entitled to. And that 60 days is a special condition of probation so that he can keep his withhold probation and terminate after the jail sentence is completed.
And that's exactly right. That's the goal.
Perfect. Sir, would you raise your right hand? Did I swear you in already? No.
No, sir.
Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So the bottom line is, you heard what the state's explanation. I just want to make sure you understand what you're doing. Actually, the state explained it very well. In order for you to do the withhold, which is better than an adjudication of guilt for you,
Right. Yes, sir.
there is an accommodation. They've got to word it in a way that the 60 days Okaloosa County Jail would be a special condition of the probation. You will still get your credit for time served. So it's essentially 60 days with credit for time served, termination of probation after you get out. So there's no further probation you'll need to follow up with, and then the cost and fees for your legal defense. So is that your understanding of what the plea is?
Yes, Your Honor.
Okay. And I see you've signed the plea agreement as well that contains this. Have you gone over this? Make sure you had all your legal questions, because does have some legal impact on you, and I want to make sure you understand that. And also that you're waiving the right to go to a trial and to contest this. You believe this is in your best interest?
Yes, Your Honor.
Okay. Very good. Based upon that, the court will accept your plea, will reinstate and modify and sentence you to 60 days in the county jail as a special condition. You'll get credit for all time served, and probation will terminate when you get out of jail if you have to spend any time in jail.
Yes, Your Honor.
Okay? Thank you very much. Good luck, sir.
Thank you.
And Your Honor, I owe the court a score sheet in this case. I will get with Mr. Morrow, and then I will let him approve the score sheet, and then I will submit that score sheet to the court.
Thank you very much. Adrian Rogers, next case. Mr. Morrow, do you know where your client is?
Oh, I believe he is, I thought he was in custody, Your Honor.
Looks like he's in custody.
Okay, it's just not on my docket as an inmate. So why don't we pass over that and we'll wait. Let's finish up with our I think that's the last. So who else is here?
I have Jamise Wright. Oh, I'm sorry.
Jamise? Okay, Jamise Wright, come forward. Would you come forward, ma'am? Oh, yes, sir. Would you announce the case, Mr. Morrow?
I thought Jamise Wright is an inmate.
What is your name, ma'am?
Foreman, Shatavia Foreman.
Okay. Hold on a second.
Yes, sir.
Remember the inmate that you went to?
Right.
Right, yeah. Jamise Wright, or business name.
I'm sorry.
That's okay.
I remember the docket.
Okay. We don't have you on the dock this morning. What, did you say this afternoon?
Yes, Your Honor, at 1:30. Oh, I thought it was long.
So she's got 2 degree classes and 1 misdemeanor. Yes.
Mr. Gates, I think this is your client.
Who is this, Your Honor?
This is Jatavia Alicia Foreman, case number 23, CF 117, and this is a new law charge. I'll be glad to accept the plea. this afternoon, but we'll go ahead and take care of it now.
After, we do have discovery, Your Honor, there's an offer in there. It does come with an adjudication, it's mandatory in the plea and alluding. I would ask the court at this time to enter a not guilty plea on our behalf and leave it set for, I think it's April the 10th.
Okay? Very good. We'll enter a not guilty plea and we'll come back for pre-trial on 4/10.
Yes, sir.
April 10th, okay? Stay in contact with your attorney before then, okay?
Yes, sir. I should. Thank you.
Make an appointment, please.
Ma'am?
Are you with the inmate? You're
No,
not.
no, no. The lady in the red.
She's here. I watch for an inmate.
Okay.
She's family, Your Honor.
That's fine. You're welcome to be here.
Your Honor,
Okay.
this is Miss Wright. As you can recall, we have reached an agreement. She just hasn't had a chance to look over the paperwork yet.
Okay. Counsel, state and full.
Yes.
Counsel.
Yes, Your Honor.
So, Your Honor, I will have a score sheet for the court this afternoon. I'll represent that Ms. Wright will score 37.2 points on this matter.
Okay, very good. You may. What, you want to, you need that to give me the terms of it? You're going to walk me through it? Okay, so give me the terms of the plea agreement.
Yes, Your Honor, this is going to be a vote terminate probation, 8 months county jail with credit for time served, $100 BOP fee, and $150 cost of defense.
Okay, very good.
And I'll ask, so I can write it, how long she has to pay. Any financials.
What are you asking for? How much? 180 days?
Would the court give her a year? I think the court.
Usually
give
we
her a year
give
because she's gonna
180
have
days is the
okay.
6 months.
She just,
It'll go to collections if it goes beyond that.
Understood.
It's not gonna be, she's not gonna violate anything or get picked up.
I don't believe the time starts till after she's released.
okay.
That's right, it's after she's released.
May I approach, Your Honor?
You may. Thank you. So, Ms. Wright, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Is this the agreement with the state?
Yes,
Okay.
Your Honor, 8 months.
So,
payment close.
Ms. Wright, you heard your attorney state the terms of the plea agreement, the core of which is the 8 months county jail. You will get credit for all time served. Is probation terminated?
Yes, Your Honor, that was my understanding.
It will be terminated pursuant to this agreement, Your Honor, revoked and terminated.
Okay. Then you need to put it in this agreement. Right. You may. Gonna take it back, make sure she initials.
May I approach?
You may. Did I swear you in already, Ms. Wright?
Yes, sir.
I've been swearing so many people in, I lose track. Okay. So, importantly, obviously, is and it's important provision, I want to make sure it's in there so you understand it, that your probation will be terminated. So you're not going to have to get out and another year of probation. It'll be revoked and terminated. It'll end. You do have to spend the 8 months in jail. You get credit for all time served. Is that your understanding what the agreement is?
All time served.
All time served.
Okay.
And that's something that the jail will calculate. We don't even know exactly what that number is. Okay, but you will get credit for time served. And that's always, even if it wasn't in the plea agreement, it's under law. You always do. You always get credit for time served. So you understand that by entering this plea agreement, you're also waiving the right to go to a trial and have a final hearing and contest all this. You believe it's in your best interest to enter into this?
Yes, sir.
And have you had all your legal questions answered of your attorney? Have any other questions regarding this plea agreement?
Yes, sir.
If you understand what it means legally?
Yes, sir.
Okay. You're entering in this voluntarily? Nobody threatened or coerced you to get you to enter into this?
No, sir.
Okay. Based upon that, Ms. Wright, the court will accept your plea agreement, revoke and terminate probation, and sentence you to 8 months in the county jail. You will get credit for all time served. The fees and costs, you'll have 180 days to pay after you get out. Okay, if not, it'll go to collections.
Yes, sir.
Any questions?
Yes, sir.
Okay, thank you, ma'am. Okay.
Reginald Howard. Reginald Howard.
Mr. Gates.
Yes, Your Honor. Travis Gates on behalf of Mr. Howard. He's before the court in 22 CF 1579.
Correct.
There's also an afternoon docket case of 23 CF 7.
Okay, hold on a second. Let me get that one. Correct.
Mr. Howard will be entering a plea of no contest in 23 CF 7 and count 2 of the information. He'll be admitting the violation of probation before the court in 22 CF 1579. May I approach, Your Honor?
You may.
State has attached a score sheet. No objection to the score sheet.
Okay, thank you. Would you announce the terms of the plea agreement?
Yes, Your Honor. Mr. Howard will be adjudicated in both cases. In 22 CF 1579, we're going to modify and reinstate the supervision, complete the original requirements, $100 cost of prosecution, $150 public defender fee, and count 2 of 23 CF 7, 11 months, 29 days of probation concurrent, waive the cost of supervision, 463 in court cost, 100 public defender fee, first offense DUI school, victim impact panel, 10-day vehicle impound, which can be waived by parole and probation if he provides proof that he doesn't own the vehicle, $500 fine, 50 hours community service work, a substance abuse evaluation within 30 days, recommended treatment within 60 days, grand year analysis. The state has agreed to dismiss count 1 of the information exchange for plea count 2.
Bless you. And that is on what case? That the dismissal of count 1?
23 of 7, Your Honor.
Okay. Okay. Mr. Howard, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement?
Yes, sir.
And I see that those same terms are contained in the written plea agreement that you've signed.
Yes, sir.
Have you gone over this plea agreement in detail with your attorney to make sure you understand all the legal ins and outs of this agreement?
Yes, sir.
Because more than just the terms, there's a lot of other stuff that's in there. You know, the fact that you're waiving the right to go to a trial, you're waiving some valuable legal rights by entering into this. And this will be a final adjudication of your case. Do you understand that?
Yes, sir.
Is the state in agreement with this plea agreement?
This is the state's agreement, Your Honor.
Okay, very good. Thank you. So, you are entering into this freely and voluntarily?
Yes, sir.
Do you have any further questions of your attorney on this case?
No, sir.
Okay. Very good. Based upon that, the court will accept your plea agreement as contained in the plea and sentencing agreement, the core of which is to, on CF 22 CF 1579, you'll modify and reinstate probation with the original requirements, and then count 2 of 23 CF 7, there'll be a new term of probation, 11 months, 29s. It'll be concurrent with the other probation. There are some additional costs and other issues that are very important. DUI, offense, school, all these things. You know, you're going to have to do the substance abuse evaluation, follow treatment. So this is kind of the beginning. It's not the end. It's important that you know. The only thing I will make 2 recommendations. 1, stay in real good contact with your probation officer.
Yes, sir.
Okay, that's key. Because if you got a bump in the road, they're going to be the ones that are going to work it out with you. Okay.
Yes, sir.
And secondly, jump on these requirements. Don't get out and wait 6 months and then all of a sudden you're running late and trying to figure out, and then they're trying to violate you because haven't done your stuff in the amount of time.
Yes, sir.
So jump on this stuff early. You got plenty of time to do it. Hopefully it'll be something that'll be positive. Okay? Any questions?
No, sir.
Okay. Thank you very much.
Dane Solomon.
Yes, Your Honor. Travis Cates on behalf of Mr. Solomon. He's making his way to the podium. Your Honor, speaking with the state about Mr. Solomon's case, at this time we'll ask the court to enter denial and continue the case without subpoenas.
Very good. So we'll come back, March 14th.
Yes, Your Honor.
Without subpoenas in the morning.
Yes, Your Honor.
Very good. Okay. Thank you very much, Your Honor.
Thank you, Your Honor.
Tony Tatum. I assume it's next.
Come on, Tony. You'll notice this is Mr. Tatum before the court in 2 cases, 20 CF 1826, 20 CF 2046, both are violations of probation. Mr. Tatum was violated for a new law violation. It's 22 CF 2572. It's a CT case.
This afternoon.
It's in Crestview, Your Honor, but it's a DUI. The state has asked Mr. Tatum to admit the new case along with the VOP for a global resolution. So the plea agreement will be incorporated in that case as well.
Okay.
Mr. Tatum is going to be, well, may I approach, Your Honor?
You may.
That way, make it easier for everybody.
There's a question attached, Your Honor, no objections. Thank you.
Mr. Tatum is going to be admitting the violations of probation before the court in 20 CF 1826, 20 CF 2046, police charged in 22 CT 2572. He'll be adjudicated all counts and cases. In 20 CF 1826, revoke and terminate probation, sentenced to a new term of 6 months community control. That will be followed by 30 months of probation for a total of 36 months of supervision. Waive supervisions, complete the original requirements, $100 cost of prosecution, $150 defender fee. 20 CF 240, or it should be 2046, I apologize, Your Honor. Revoke and terminate probation.
This is 2046?
Yes, Your Honor.
Okay.
No, actually, I apologize, it's 2406.
Okay,
I've got them.
that's the one, the main thing is that the right one in writing.
Yes,
Go
Your
ahead,
Honor.
Go ahead.
That one is correct.
Okay.
We're going to revoke and terminate probation, a new term of 6 months community control, followed by 30 months of supervision, waive cost of supervision, complete the original requirements, $100 cost of prosecution, $150 defender fee, and then in 22 CT 2572, a year of probation, concurrent waive cost of supervision, substance abuse evaluation within 30 days of his release, recommended treatment to begin within 60 days of release, random urinalysis, 50 hours of community service work, $500 fine, DUI school, victim impact panel, 10-day vehicle impound, which can be waived if he provides proof of not owning a vehicle, 6-month driver's license revocation, and I'm realizing I didn't put in the court cost, which would be $463, and the public defender fee of $100.
Okay. I have one question.
Yes, sir.
And I think I know the answer, but it's not clear in here.
Yes, sir.
You have on 1826 and 2406, you have 6 months of community control, and then it says concurrent.
Yes, sir.
Followed by 30 months of probation. The next one, it says concurrent after community control, but after the probation, it doesn't say.
Yes, sir.
So I'm assuming that all the probation will run concurrent, both the community control and then the regular probation. The full 36 months will be concurrent with each other.
Yes, sir.
Okay, I assume that, but I don't want to assume anything. Because you want whole purpose of me, and I'm going to ask you some questions, Mr. Tatum, is to make sure you understand what the agreement is, and then you're entering it freely and voluntarily. That's the whole purpose of my question. So I need to swear you in first, though. Would you raise your right hand? Do you swear or affirm the information you're about to provide the scores of truth, nothing but the truth, so help you God?
Yes, sir.
Is the state in agreement?
Yes, the state is in agreement.
So you heard the terms of the plea agreement that your attorney had, correct?
Yes, sir.
And you also have those same terms that are contained in the plea and sentencing agreement which you've signed.
Yes, sir.
Now, one question that I have regarding the sentencing agreement, this appears to be a downward departure.
It is indeed, Your Honor.
And
based upon a legitimate, uncoerced plea bargain.
okay. That's what I wanted to make sure and get that on the record. So, again, you heard the terms of the plea agreement, and have you gone over this plea agreement with your attorney? Make sure you understand all the legal ins and outs of this, because you're waiving the right to go to a trial on this. You're waiving the right to confront witnesses, and it affects your ability to appeal this. Do you understand? Have you gone over that with your attorney? Make sure you understand it.
Yes, sir.
And that this will be importantly, this will be a final resolution of your case. Okay? You understand that? Any other legal questions you have of your attorney?
No, sir.
Okay. You satisfied with your legal representation? Yes?
Yes, sir.
Okay. I didn't want to put words in your mouth. I saw you shaking your head. Yes, that's the only reason I said that. If you don't like him, I want you to tell me. He usually does a pretty fine job. finally, you're entering into this freely and voluntarily?
Yes, sir.
Okay. Very good. Based upon that, the court will accept your plea agreement on 20 CF 1826 and 20 CF 2406. The court will revoke and terminate probation. There'll be new terms of 6 months community control followed by 30 months of probation. Those will be concurrent with each one of each, so they'll run at the same time. Have all the same requirements with, of course, the cost of prosecution and the public defender fee that'll have to be paid during the term of the probation. Do you understand that?
Yes, sir.
And then the other one has to do with 1129 of probation on the DUI charge. There's some other important substance abuse evaluation that are required and random UAs, community service, different things that are contained in here. Do you understand all those?
Yes, sir.
Okay. The only thing I mentioned it to the gentleman before you. 2 things. Stay in good contact with your probation officer. This is 36 months, 3 years. I want you to be successful. It's going to require some effort on your part. You can't just say, oh, I'm getting out. Oh, good. Let me sign. This is just the beginning. You got to stay in contact with them and jump on these requirements. Hit them in the first month. Don't wait 6 months or you're running up against the year and now they're threatening to violate you. Don't do that. Start in and get on it early, okay?
Yes, sir.
Okay. Any questions?
No, sir.
Okay, thank you very much.
Senator Beecham? Your Honor, Cedric Taiwan Beecham is before the court. He's here on a motion for bond reduction filed in 20 CF 586, 20 CF 1938. And I do want to clarify that he does have a signature bond in the new law case, 22 CF 2923. The reason that he was denied bond in the VOP cases is that case in which he has a signature bond. He has a local business. He's lived here for decades. He has children and a wife that need his support. He's never failed to appear. I would respectfully submit, even though it's a VOP and he's not entitled to a bond, that it would be appropriate for the court to consider a cash or professional bond in the VOP cases. He could have pretrial services. He could have a scram monitor. He could even have a GPS if that was a concern, but I don't think, because he's never failed to appear, that there would be a concern that he would be a flight risk. Because of his long ties to the community and because there are less intrusive means of dealing with his pretrial time period, I would ask for the court to please consider a cash or professional bond with appropriate conditions. Thank you.
State.
Your Honor, Mr. Beecham actually is, like Mr. Medina said, he's not entitled to a bond on a violation of probation. He's also not entitled to a bond on this charge because he is listed as a violent felony offender of special concern. He cannot, I don't think the court can give a bond on the violation of probation. He has...
Let's just stop there. Do you disagree that he's with the label violent felon of special concern, Mr. Medina?
I don't have that information. Was that part of the paperwork with respect to his being going first appearances?
Yes, Your Honor. On the violation report, it has the violent felony offender of special concern label.
Because if he's properly meets those criteria, I think I cannot offer any bond.
I can't stipulate, Your Honor, if he wants to address that issue.
I'm asking you a legal question. Do you disagree with me
It's not
that if he's
illegal.
labeled as a violent felon of special concern under the law, that I am not allowed to give him a bond? Do you disagree with that? Or if you don't know?
I disagree that it's a legal question, Your Honor. It involves a factual presumption that I don't have the information on. I'm asking him if he wishes to address the issue of whether he is factually based on priors that I don't have full knowledge of his priors. He may have information with respect. And I don't think it's just purely a legal question, so I can't answer it in a legal manner.
Your Honor. Would you raise your right hand?
Yes, sir.
Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
And you understand that this is being recorded. Anything
Yes.
you say can or could be used against you in a court of law.
And
Yes,
I'm instructing him only to talk if he has knowledge of whether he would be, under the law, a violent felony offender of special concern based on priors. Do not discuss the current charges or VOP in any way.
Yes, sir. Certainly, certainly. I know y'all are busy. We've had this.
Not busy, this is my job.
Thank you, sir. We had this before where they tried to get me with the violent felony offender of special concern on the bond hearing I've had years ago. And we actually got them to reverse that because I didn't fall under the criteria with the charges. I don't know the section number because I wasn't expecting this, but no, sir, I do not fall under that. And they also had, the judge at the time was Gutierrez, and we had to come back to court on it, and he had to look over that, and they went through the charges, and I had community, because the business I run is a community-based business, and we do things for the community. So it was found I was not a threat to the community, and that I wasn't.
May I interject, Judge? Because I think this might help with what he's referring to. In these cases, or at least in 20 CF 856, I would ask the court to please take judicial notice of the order by Judge Gutierrez on May 12, 2020, where cash and professional bonds were granted in this case, along with appropriate special conditions. So I believe that Mr. Beecham is correct. I don't have the particulars of the conversation, but I think the record reflects that he is correct that bond has been previously entered.
I don't mean to interrupt, but here's what I'm going to do. I have a question. So you probably know this, but I'm going to tell you this so that you kind of understand what I'm doing. If this label is correct, if there is a violent felon of special concern, if it meets the criteria, certain things, priors and all that, you understand that?
Yes, sir.
If it meets that, my hands are tied. I can't even get it. I can't even order a bond. I'm not sure what's going on here, but there's I'm going to continue this to let everybody look into this issue to see if it is. If it is, then we'll look at a bond. But I don't even have an option to do it until then. So until I get past that threshold, I'm not even going to consider a bond. All the stuff about community, none of that matters.
Yes,
if it's this label, I'm upholding to the law the same as you are.
Yes, sir, I understand.
And so we'll continue this. How long?
Your Honor, he's coming back tomorrow anyway. We may be discussing a resolution. I don't know. So if we could just.
We'll come back tomorrow. But I will say to you, if you haven't been able to whatever verify or work on those things tomorrow, I'll continue it beyond tomorrow. But let's just come back tomorrow, see where we're at. But this is pretty straightforward. Either there's a proper label or there's not. Either you are or you're not. It's based on, criteria. You meet certain criteria, boom, they put
yes, sir. Like I say, that's why I remembered that because they did it.
I understand what you're saying. That's why I'm
problem.
I'm not denying it.
I appreciate it.
Okay.
Because I understand what you're saying.
We'll be here tomorrow. Thank you.
Thank you.
Thank you.
Mr. Colbert?
There's one that's on my docket that's not on the, I've got did we already do Derek Brown?
Yes, sir, we did Derek Brown. He was one of the unrepresented.
Good morning, Ron.
There were 200 representatives.
Okay, because it says he's representing. We'll come back to it. I'm sorry.
Your Honor, Steve Medina with Jason Christopher Coulthart. He has 5 DOP cases, 19 CF 2339, 20 CF 341, 20 CF 298, 20 CF 299, and 20 CF 588 by my list here. There also is a new law case, 22 CF 3184, that's on the afternoon docket. At this point in time, because the state has indicated to me this is going to be a substantial DOC offer, he would enter a denial on the VOP cases, and we can go ahead and have him enter a plea of not guilty in 22 CF 3184 as well to take him off the afternoon docket if that's appropriate.
Very good. So on the new law charge, 22 CF 3184, the court will enter a not guilty plea. We'll come back on our pretrial, our next pretrial date, which is April 12th, and on the 5 VOP cases here today, the court will enter denials, and we'll track with the pretrial on 4/12.
Thank you, Your Honor. Is it 410 or 412?
412 for the inmates.
For the inmates, yes, Judge. Thank you.
Sure. 412.
412.
412.
Yes. Thank you very much.
Thank you, Your Honor.
Roger Adams.
Ryan Morrow for Mr. Adams, Your Honor. This is 22 CF 958 Alpha. The case is VOP. Second? Yes, sir. Yes, sir.
Okay. I'm sorry. What's the name again?
The name is Roger Adams, Your Honor.
Sorry. There you go. Got it. Go ahead.
And we're going to be entering a plea to VOP, Your Honor, negotiated plea.
Yes, sir.
For 1129 in the county jail.
Go ahead and announce in detail the terms of the plea agreement,
Yes, Your
Counselor.
Honor. We're going to be revoking and terminating probation, sentenced to 1129 in the county jail, credit for time served, $100 VOP fee, $150 cost of defense, 180 days to pay, and then reduced to a lien.
Very good. Is that stated in agreement?
Is it Mr. Adams?
Yes.
Yes, that is the state's agreement for Mr.
Okay.
And Your Honor, this, the underlines are misdemeanors. We will not need a score sheet.
Okay. Thank you. No, hang with us.
May I have a moment, Your Honor? I want to make sure I have this right on plea agreement before I hand it to you. May I approach, Your Honor?
Mr. Adams, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Now, is the 1129 for each of the two charges, counsel?
It is a concurrent 1129.
Okay. It's not what this says. You got to be precise with what you're saying. There,
Yes,
with
Your
each of
Honor.
the charges, 1129, they'll be served concurrent.
May I approach?
Okay. Okay, Mr. Adams, you heard your attorney state the terms of the plea agreement, and I see that you've signed a plea and sentencing agreement that contains the same terms, the core of which is to revoke and terminate probation for each of the two charges, 1129, basically just a day less than a year of probation for each, 1129 county jail. Credit for time served, that's credit for all time served. Both charges will be and both the sentencing will be dealt with concurrently. So you won't have, it's a total of 1129, not 1129 times 2. Okay. So in addition, there are fees and costs. You'll have 180 days to pay upon release, and then reduce to a judgment after that. You understand? Is that your understanding of what the agreement is?
Yes, sir.
Okay. And have you gone over this and read this plea and sentencing agreement closely?
Yes, sir.
Do you understand all that you're waiving some valuable legal rights by entering into this? You're waiving the right to go to a trial.
Oh, yes, sir.
You're waiving the right to confront witnesses.
Yes, sir.
And this will be a final adjudication of your case, and it actually limits your right to appeal. All those rights are waiving in order to enter into the deal.
Yes, sir.
Is that what your understanding is? Just want to make sure you're doing it.
Yes,
I didn't realize that. Okay. So do you have any other legal question or any other questions for your attorney?
Yes, sir.
Okay, and you entered this freely and voluntarily?
Yes, sir.
Okay, very good. Thank you very much. 1129 in the county jail for both charges, credit for time served. Thank you.
Thank you, Your Honor.
Counsel?
Your Honor. Yes, sir.
Alicia Castillo.
Castillo.
Ryan Morrow for Mr. Castillo, Your Honor. With the acquiescence of the state, no objection, we're going to ask that this be set to next week's hearing date. I've provided them with some information, and we're hoping that they will provide a resolution for this matter.
Very good. So we'll enter are we entering a denial here
Yes, Your
today?
Honor.
Or
For today. I think it may have already been done.
Come back on 2/21 in the morning without subpoenas at 9 a.m. Okay, thank you.
Anthony Griffin.
Ryan Morrow for Mr. Griffin, Your Honor. He has been preliminarily approved for mental health court. He's set to observe next week. I would ask that this be set on the March docket to give him an opportunity to get through the observation period.
Okay. State?
Your Honor, the state's not amenable to mental health court at this time.
Not amenable?
No, he's observing mental health court because he's been approved by mental health court. He's not been approved by the state.
Okay, so what do we need to do here today?
Set him for a contested hearing. He has a 36-month suspended sentence, and I believe he's a violent felony offender of special concern.
So why don't we do this? We'll this is kind of a curveball. Looks like from the defense. So what I'm going to do is I'm going to enter a denial. We'll come back in the morning without subpoenas, not for a contested hearing, in the morning on February 21st in the morning to give you all a chance to chat some more. If there's not a resolution that's amenable by both sides, you need to be talking with the state. If there's not an agreement, then we'll come back on February 21st and we'll set a trial. And so at that time, you can let me know how long you need and we'll set it, and it'll be done in the afternoon. We will not have a trial on February 21st. We'll do it in the morning at 9 a.m., just a regular miscellaneous docket. Okay?
Thank you, Your Honor.
Thank you, sir.
Thank you. Appreciate it. That's a good question. He's got a mental health court date? Is that any note?
Your Honor, he had not actually gone to mental health. I'm the mental health court prosecutor. He had not actually gone to mental health court. But now that I know Ms. Sandler's position about the case, if he can be removed from the mental health court docket and not observed, then that would be, because what they're going to do is next Wednesday, they will transport him from the jail to mental health court. And if Ms. Sandler is not willing to allow him to do mental health court, then there's no reason for him to be transported.
Okay, very good. Thank you. Good question. Thank you.
Darren Potts.
Okay. All right. Your Honor, I'm here with Mr. Potts.
This is case number 14 CF 1480.
Yes, Your Honor, Ryan Morrow for Mr. Potts in that matter. I think at this point I would ask that this be set on the 21st as well. The state has brought an alternative resolution to my attention since sending this paperwork back to Mr. Potts. Ms. Potts has asked some questions about his time served as original judgment and sentence that I can't answer as I sit here right now.
Okay, very good. So we'll enter a denial. We'll come back without subpoenas on February 21st in the morning at 9 a.m.
Sure, we'll figure it out.
Adrian Rogers.
Adrian Rogers.
Ryan Mark and Mr. Rogers, Your Honor. This is 18 CF 1411 and 18 CF 2431. We're going to be entering a plea and an intermission on the VOP. It's going to be to revoke and terminate the probation. 1129 days in the county jail with credit for time served. $100 VOP fee, $150 cost of defense, and 180 days to pay, and then financials will reduce to a lien, and this is to be concurrent on all the matters before the court.
Okay. State in agreement?
Sorry, Your Honor, I just need to check my records.
Okay.
That is the state's agreement, Your Honor.
Thank you. I'm sorry. What's the adjudication?
It will be an adjudication.
Adjudication, okay. Correct? Is that?
Yes, Your Honor.
Okay. Thank you. Okay. I'm pretty sure I understand what you're wanting to do, but I want to make sure it's committed to writing. The 1129 Okaloosa County Jail sentence would be for each of the 4 charges.
Yes, Your Honor, concurrent across.
You got to put that in there. Got to be for each of the charges. It's got to be clear.
I have it here on the right, concurrent across counts and cases. I didn't know what that is.
It should say something to the effect of 1129 for each count.
Okay.
So, Mr. Rogers, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard your attorney state the terms of the plea agreement.
Yes, sir.
Revoke and terminate probation, and the core of which is the 1129, 1 day less than a year in the county jail. Credit for all time served. Is that your understanding of what the agreement is?
Yes, sir.
And I see you've signed the plea and sentencing agreement. Have you read through this thing? And
Yes, sir.
gone over it with your attorney?
Yes, sir.
Make sure you understand the terms, the legal ramifications of this, because by entering into this, you're waiving some valuable legal rights. Right to go to a trial, to confront witnesses, it affects your right to appeal. Have you gone over all that with your attorney? Make
Yes,
sure
sir.
you understand that? Okay. And you're entering into this freely and voluntarily?
Yes, sir.
Okay. Nobody threatened or coerced you to get you to enter into this?
No,
court?
sir.
Okay. Very good. Based upon that, the court, that testimony, the court will accept your plea agreement. The court will revoke and terminate probation, sentence you on each of the 4 counts to 1129 in the Okaloosa County Jail. You will get credit for all time served. All the fees and costs are contained in the plea agreement. You'll have 180 days after you get out to pay. If not, it'll go to collection, go to a lien.
Yes, sir.
Okay? Very good.
And Judge, if I may, this is another case in which I'll leave a score sheet that I'm going to provide this afternoon.
Okay.
Mr. Rogers will score 48.8 points. This is a downward departure based upon uncoerced plea bargaining.
Very good. Thank you very much for informing me of that. Okay, any other questions?
No, sir.
Thank you.
Robert Taylor.
Ryan Morrow for Mr. Taylor, Your Honor. This is 20 CF 3063. This is going to be a plea straight up to the court. Mr. Taylor has a 5-year suspended sentence.
Okay, so speaking of that mic for me, I'm having a hard time hearing you.
This is going to be a plea straight up to the court, Your Honor. There's no deal on the deal. People were going to enter an admission, ask the court set this off for sentencing.
Okay, very good. You may.
I don't have anything written in for the sentence to be imposed, because this is a plea straight up. I'm not sure if there's something the court's looking to see. I want to make sure.
Let me look at it. What is this?
It just says plea straight up, and he has a 5-year suspended sentence, Your Honor.
He currently has a 5-year suspended sentence?
He does, Your Honor.
Okay.
And we will be asking to vacate that. I don't have the score sheet, Your Honor, because we didn't anticipate the plea, but I will put on the record he does score up to 93.8 points presumptive as a minimum guideline, maximum of 5 years.
Okay. So what's the 99 months? What's that?
Your Honor, his score
My
sheet.
calculation on late in the morning.
Your Honor, the score sheet that he would be before the court on would be 93.8 points.
Yes.
Which is a minimum guideline of, I have to look, it's about 46 months minimum guidelines. But
Counsel, are you clear about the score sheet? Are you okay with the score sheet?
I would need to see a copy to know and go over it. I haven't
So
received
why
a
don't
new
we do
score
this?
sheet.
I think we need to get a score sheet. We need to make sure this is good and clean. I'm not clear about this, the 5-year suspended sentence. You're just informing the court of what already is. They're going to be seeking, I mean, you can tell the court, hey, it's a five-year suspended sentence. That's good, but that's not a part of the plea agreement. It's just confusing. So I'm going to give this back to you, and I'm going to continue this maybe till next week on February 21st. Can we get a score sheet?
Oh, yeah, I can get that this afternoon. To
Yeah,
Mr.
get a score
Moore.
sheet, get it good and clean with the language so that it's clear what we're doing as far as a plea to the court, okay?
Understood, Your Honor.
And then at that time, I'm going to ask him some questions just to make sure he understands, you know, what are the range of possible outcomes. So this will be in the morning on the 21st. Okay. Thank you very much. Okay. Thank you, sir. Officer By, I believe it's a wrap.
That's a wrap on inmates. Someone came in, we're just giving a second.
Okay.
So that's it. They can all look at it.
Anything further for the good of the court here? Okay. Thank you all. We'll see you at 1:30.
You're good. And I thought it was